If someone owes you money, if a company refuses to refund you, if a tradesperson botches a job and then disappears, you might be sitting there thinking, what can I actually do about this? Most people feel powerless in these situations. They assume the only way to fight back is to hire an expensive solicitor, spend thousands on legal fees, or just accept the loss and move on. But in the UK, that's simply not true. You have a powerful, accessible tool at your disposal, the Small Claims Court. And today, I'm going to walk you through exactly how it works, when to use it, how much it costs, how long it takes, and the biggest mistakes people make that can cost them their entire case. By the end of this video, you'll know whether the small claims process is right for you, and how to give yourself the best possible chance of winning. Let's get into it. Section 1. What is the Small Claims Court? The first thing to understand is that the Small Claims Court isn't a separate building or a special courtroom. It's actually a track within the county court system designed for straightforward disputes involving relatively small amounts of money. In England and Wales, the small claims track usually covers claims up to £10,000. In Scotland, the equivalent is called the simple procedure, and the limit is £5,000. In Northern Ireland, the limit is also £5,000. The whole point of the small claims system is to make justice simple, quick, and accessible. You don't need a lawyer. You don't need legal jargon. You don't need to be an expert in anything. It's designed for ordinary people who just want a fair resolution to a dispute that hasn't been sorted out any other way. Think of it as the legal system's way of saying, you don't need to be rich to stand up for yourself. Section 2. When should you use it? The small claims process is perfect for everyday disputes, the kinds of problems that happen to normal people all the time. For example, a tradesperson who didn't finish the job. A landlord refusing to return your deposit. A business that won't refund you. A neighbor who damaged your property. Money you lent to someone who won't pay it back. Faulty goods or services. Car repairs gone wrong. Disputes over simple contracts. A builder who overcharged you. A mobile phone company billing you incorrectly. A cleaner or gardener who didn't do the work you paid for. But here's the key question, is it worth it? You should consider using the small claims court when you've tried to resolve the issue informally. You have evidence to support your claim. The amount is worth the time and cost. The other side is likely to pay if you win. The dispute is simple enough for a judge to understand quickly. And here's when you shouldn't use it. Personal injury claims over £1,000. Complex legal disputes involving technical arguments. Claims requiring expensive expert witnesses. Cases where the defendant has no money or assets. Situations where you're seeking something other than money, like an injunction. This last point is important. If the person you're suing is broke, the court can't magically make money appear. You might win the case but still never get paid. Section 3. Try to resolve it first. Before you even think about filing a claim, the court expects you to try to sort things out yourself. This is called pre-action conduct, and it's taken seriously. It means contacting the other party, explaining the issue clearly, asking for a reasonable solution, giving them a fair deadline to respond, keeping records of everything. If you skip this step, the judge can penalize you, even if you win. They might reduce the amount you're awarded or refuse to reimburse your court fee. So always start with communication. Keep it polite. Keep it factual. Keep it documented. A simple email like, "Hi, I'm contacting you regarding the issue with X. I'd like to resolve this amicably. Please respond within 14 days. Can save you a lot of time and money." Section 4. Send a letter before action. This is where things get serious. A letter before action, also called a letter of claim, is a formal warning that tells the other party what the dispute is, what you want, how much you're claiming, Why you believe you're entitled to it. A deadline for them to respond, usually 14 days. That you will start court proceedings if they don't reply. This letter is crucial. Judges love it because it shows you've acted reasonably and given the other side a fair chance to avoid court. And honestly, a lot of people cave at this stage because they realize you're serious. If you're dealing with a business, they often have entire departments dedicated to avoiding court claims, so a proper letter before action can get results very quickly. Section 5. Filing the claim. If they ignore your letter or refuse to cooperate, it's time to file your claim. In England and Wales, the easiest way is online through Money Claim Online, MCOL, for simpler claims. Civil Money Claims, CMC, for more detailed claims. You'll need the defendant's full name and address, a clear explanation of what happened, the amount you're claiming, evidence you already have, the court fee. The court fee depends on the size of your claim. For example, a £500 claim costs less than a £5,000 claim. The good news is, if you win, the other side usually has to reimburse your court fee. Once you submit the claim, the court sends it to the defendant. They then have 14 days to respond. Or 28 days if they acknowledge the claim. They can admit it, defend it, partially admit it, ask for more time, ignore it. If they ignore it, you can request a default judgment, which is basically an automatic win. Section 6. Preparing your case. If the defendant disputes the claim, the court will move it to the small claims track. This is where preparation matters. You'll need to gather contracts, emails, text messages, photos, receipts, bank statements, quotes, screenshots, witness statements, expert reports, if cheap and relevant. The judge wants a clear, chronological story. Think of it like this: if a stranger read your evidence, would they understand what happened? If the answer is no, organize it better. You may also be asked to complete a directions questionnaire, which helps the court understand what the case is about, whether you want a hearing, whether you need an interpreter, whether you have witnesses, whether you're available on certain dates. Most small claims cases are decided at a short hearing, often lasting under an hour. Section 7. The hearing. This is the part that scares people, but it really shouldn't. Small claims hearings are informal. You don't stand in a witness box. You don't swear on a Bible unless you want to. You don't need a lawyer. You sit at a table with the judge. The judge asks questions. You explain your side. The other party explains theirs. A few tips. Stay calm. Stick to facts. Don't interrupt. Don't get emotional. Bring printed copies of your evidence. Be polite, judges hate rudeness. The judge will usually give a decision on the spot. They can order the defendant to pay you. You to pay the defendant. No money to be paid if neither side proved their case. If you win, the judge can also order the defendant to pay your court fee, limited expenses, interest. But remember, you won't get back legal fees, even if you hired a solicitor. Section 8. Enforcing the judgment. Winning is one thing. Getting paid is another. If the defendant refuses to pay, you can enforce the judgment using bailiffs, county court or high court enforcement officers. Attachment of earnings, money taken from wages. Charging orders, against property. Third-party debt orders, freezing bank accounts. High court enforcement officers are often the most effective. They can seize goods and have more authority. But remember, if the defendant genuinely has no money, enforcement may not work. Section 9. Common mistakes to avoid. Here are the biggest errors people make. Crossmark 1. Filing a claim too early. Always try to resolve it first. Crossmark 2. Not sending a proper letter before action. Judges expect it. Crossmark 3. Poor evidence. If it's not written down, photographed, or recorded, it's weak. Crossmark 4. Claiming the wrong amount. Be precise. Overclaiming looks bad. Crossmark 5. Getting emotional. Stick to facts, not feelings. Crossmark 6. Suing someone who can't pay. A judgment is useless if the defendant has no assets. Crossmark 7. Not preparing properly for the hearing. Organization wins cases. Crossmark 8. Assuming the judge will see the truth. Judges rely on evidence, not vibes. Section 10. Is it worth it? For many people, yes. The small claims process is affordable, straightforward, designed for non-lawyers, often faster than you expect. A great way to stand up for yourself. But it requires patience, organization, realistic expectations, a willingness to follow the process properly. If you found this breakdown helpful, hit the like button so more people can find it. And if you want more videos on UK law, from consumer rights to landlord disputes to dealing with dodgy traders, make sure you subscribe. Drop your questions in the comments and I'll cover them in future videos. Thanks for watching, and good luck with your claim.